Welcome to the Deep Dive. We take complex topics, unpack them, and give you the essential knowledge. Today, we're plunging into a really foundational case for open government law here in Florida. It's a decision that, honestly, still shapes how we deal with public records access today. So if you're someone who needs to quickly get the nuances of legal precedent, especially around public information, this deep dive is definitely for you. We're looking at Waite v. Florida Power and Light Company. It's a 1979 Florida Supreme Court decision. And our mission is to unpack the critical questions it tackled: public records, yes, but also court rules versus legislative power.
Yeah, this case, wait, it was quite the showdown. You had a city utility commission facing off against Florida Power and Light, a huge company. And it was all about getting access to records. The Florida Supreme Court basically had to draw some really clear lines about things like automatic stays on appeal, and crucially, what actually counts as an exemption under the public records law. It's almost a perfect example of how different government branches sort of stake out their territory when it comes to information control.
And we're going straight to the source, the Supreme Court's own opinion. That's where they laid out these distinctions. Okay, let's get into it. So the core players: the City of New Smyrna Beach Utilities Commission. Let's just call them New Smyrna for simplicity. They were the petitioners.
Right.
And opposing them, Florida Power and Light Company, or FTL, the respondent. And interestingly, these two were already tangled up in separate litigation before the U.S. Nuclear Regulatory Commission, so there was context there.
Absolutely. And FPL, likely as part of that broader fight, wanted to see New Smyrna's records. They were looking for documents about planning, operations, maintenance, basically the inner workings of New Smyrna's electrical system. And they made the request under Florida's Public Records Act, Chapter 119.
Okay.
But New Smyrna denied access. They said their lawyer needed to check the documents first, maybe pull out things they considered privileged or confidential.
Right, the standard attorney review claim. So FPL didn't just accept that.
No, not at all. They went straight to circuit court seeking what's called a writ of mandamus.
Yes, mandamus. Basically telling a government body, you must do this.
Exactly. FPL wanted the court to force New Smyrna to hand over all the documents. And the circuit court agreed with FPL, granted the mandamus, and they made the order effective really quickly within 48 hours.
Wow. 48 hours.
Yeah, and that ruling was then upheld by the First District Court of Appeals. So New Smyrna was really under the gun to disclose.
Okay, so that sets the stage for the Supreme Court. This is where the Waite case really lands. Two main issues they tackled. The first one is this classic conflict, court rule versus state law. It's all about automatic stays. The question being, when a public agency appeals a court order saying, open your records, does that appeal, just by being filed, automatically stop the order? Does it put everything on hold?
It's a huge procedural point, and the conflict was, well, crystal clear. You had Florida Appellate Rule 5.121, which pretty explicitly said, public body files an appeal, the order is stayed. Automatic.
Actually, it seems straightforward.
But then you had Section 119.1112 of the Public Records Act itself. And the legislature wrote in that statute that such an appeal does not operate as an automatic stay.
So direct contradiction. Rule says stay, statute says no stay.
Exactly. And the courts below were even split. The First District in this case, said the statute wins. But previously, the Fourth District in a case called Clark v. Walton had said, no, the appellate rule takes precedence. So you had conflicting signals from the district courts.
Okay, that makes sense why the Supreme Court had to step in.
A shame.
So New Smyrna's argument, they obviously pushed for the rule, right? They argued granting a stay is procedural, how courts manage cases. And they pointed to the Florida Constitution, Article V, Section 2, which gives the Supreme Court power over court procedure. Essentially saying, this is about how litigation works. That's the court's turf, not the legislature's. They cited Benyard v. Wainwright about procedure being the means and method.
And FPL countered that, no, this rule about the stay, Rule 5.1 and 01, it's actually substantive. Their argument was that an automatic stay wasn't just procedure. It could kill their actual right to get the records under Chapter 119. If disclosure gets delayed forever by appeals, the right itself becomes kind of meaningless.
That makes sense, too. A right delayed is a right denied, essentially.
Right. But the Supreme Court, well, they didn't buy FTL's argument on this point. They sided with New Smyrna and the Fourth District's Clark decision. They ruled that filing the appeal does trigger an automatic stay.
So the court's rule trumped the statute.
Yes. They doubled down, saying granting a stay is procedural. It falls squarely within their constitutional power to manage how courts operate.
Okay, but that wasn't the unanimous view, was it? I remember reading about a dissent.
That's right. And this is where it gets really fascinating, kind of highlights the tension. Justices Sundberg, England, and Adkins wrote a partial dissent. They actually agreed, yes, a stay is technically procedural, but, they argued, Rule 5.121 was just the court's general policy. Section 119.112, the statute saying no stay, was a specific legislative policy choice made just for Public Records Act cases. They called it a twilight zone, a gray area where maybe the specific statute, which was clearly designed to make the act work quickly and prevent agencies from just stalling, should override the general court rule.
So the dissenters were saying, look at the purpose here. The legislature specifically wanted to stop delays in these cases.
Precisely. They felt the majority's approach could frustrate the whole point of the Public Records Act, but the majority held firm. So this part of the ruling really underscores that ongoing tug-of-war, judicial rulemaking versus legislative intent, especially when it comes to something as fundamental as government transparency.
Yeah, it shows how procedure can have real substantive impact. The court protected its procedural domain, but it potentially gave agencies a tool for delay that the legislature tried to take away.
Exactly. A crucial point about separation of powers.
Okay, so that's the procedural battle. Automatic stay wins. But then there's the second huge issue, maybe even more impactful long-term. What actually counts as secret under the Public Records Act? Can agencies withhold records based on traditional common law privileges, things like attorney-client privilege or work product?
Right. That was New Smyrna's next big argument. They pointed to the exemption section, 119.072A, which at the time exempted records provided by law to be confidential. They argued that provided by law should include these well-established common law privileges. These weren't statutes, but they were definitely part of the law in a broader sense, they claimed.
Okay, so they're saying law means more than just statutes passed by the legislature.
Correct. But this is where, again, legislative history becomes absolutely key. You have to look at the words the legislature used and how they changed.
Ah, the wording changed. Tell us about that.
So the original version of that exemption section didn't say provided by law. It said records deemed by law to be confidential.
Deemed by law. Subtle difference.
Very subtle, but hugely important. Because under that deemed by law language, you had a case, Wisher v. News Press Publishing Co., back in '75. And in Wisher, a district court actually did say that non-statutory public policy ideas could be used to keep records secret. The deemed by law language opened the door for judges to basically create exceptions.
Interesting. So the courts were carving out exceptions under the old language.
They were starting to, but then, and this is a critical part, in 1975, right after Wisher, the legislature stepped in and amended the statute. They specifically took out deemed by law and put in provided by law.
Uh-huh. So a deliberate change in wording.
Extremely deliberate. And another court, the 4th District and State, Exrel, Veal v. City of Boca Raton, picked up on this. Judge Schwartz, in that Veal case, said the very purpose of that 1975 amendment was to shut down what happened in Wisher. It was meant to stop courts from creating their own exceptions to the Public Records Act.
Got it. The legislature wanted to reclaim control over what's secret.
Precisely. They were saying if it's going to be an exemption, we will provide it in a statute.
So how did the Supreme Court handle this? Did they follow Veal?
They did. They fully adopted the reasoning from State Extire Veal. And this was a massive win for public access advocates. The court held very clearly that the legislature, by changing that wording, intended to exempt only those records made confidential by statutory law.
So no room for common law privileges like attorney-client or work product unless a statute specifically says so.
Exactly. The court basically said, if you want attorney-client privilege or work product to be exemptions under Chapter 119, that's fine, but it is up to the legislature and not this court to amend the statute.
Wow. That's a really strong statement about legislative supremacy on exemptions.
It is. It means unless the Florida legislature writes it down as secret in a law, it's public. Full stop.
So even things we traditionally think of as confidential, like a city attorney's legal advice to the city commission. That's potentially public unless a specific statute protects it.
That's the implication. The court was emphatic. Their job is to interpret the laws the legislature writes, not to judge the wisdom of those laws. They're not there to create policy or decide what should be secret. That's the legislature's job. This ruling hammered home that principle. Exemptions come from statutes, period.
Okay, so Wake really narrowed the definition of confidential under the Act. But New Smyrna had a couple of other arguments, didn't they? Sort of last-ditch efforts.
Yeah, a couple more tries. First, they argued waiver. They said because FPL was already fighting them in that Federal Nuclear Regulatory Commission case, they somehow gave up their right to use the Florida Public Records Act.
Like you can only pick one venue to fight in?
Kind of, but the Supreme Court just swatted that down, found no legal basis for it at all. They basically said, pursuing your rights in federal court doesn't stop you from using a separate state statute to get public documents. One doesn't cancel out the other.
Makes sense. And the other argument, something about reciprocity.
Right. This one was pretty creative. New Smyrna argued that the statute says disclosure must be under reasonable conditions. They tried to stretch reasonable conditions to mean that if FPL got New Smyrna's records, FPL should have to open up its comparable records to New Smyrna, like a tit for tat.
So turning the Public Records Act into a kind of discovery tool against a private company.
Exactly. But the court said absolutely not. Reasonable conditions, they clarified, means practical stuff, protecting the records, maybe setting appointment times, how copying happens. It does not mean forcing reciprocal disclosure from the requester, especially a private entity. The court drew a firm line. Getting public records under Chapter 119 is totally different from the discovery process you have in litigation.
Okay, so those arguments didn't fly either. So let's sum up this deep dive into Waite v. Florida, Power and Light. It feels like a truly landmark case. The Supreme Court came down hard on the side of statutory exemptions, saying only the legislature can make records secret. But on the procedural side, they upheld the court's power, allowing that automatic stay, which could potentially slow things down. It's a fascinating balance, or maybe tension.
Absolutely. Connecting it to the bigger picture, Waite set this incredibly high standard for what counts as an exemption in Florida. It really put the ball squarely in the legislature's court. If you want something kept secret from the public, you need a specific statute saying so. It's become a cornerstone reference point for understanding that dynamic between the courts and the legislature in defining public access. It wasn't just a technical ruling, it was defining the scope of public knowledge.
It really makes you think, doesn't it? How much those tiny shifts in legal language, deemed by law versus provided by law, how much impact they actually have on our ability to access information and ultimately to hold government accountable. And looking forward, you have to wonder, as government records become more complex, more digital, will new gray areas emerge? Will we see new fights over access where the lines drawn by Waite might need revisiting or reinterpreting by future legislatures or courts? It makes you think about what the next transparency battleground might be. Thank you for joining us on this deep dive. We hope exploring Waite v. Florida Power and Light Company gave you some valuable insights into the often complex but always important world of open government law. Until next time, keep digging for that knowledge.